All right, I think we're going to get started now. I always like to give a couple minutes for people who might be coming late. Just give me a second to get everything situated, and we're going to jump right into it. So welcome to the Micklin Law Group's monthly webinar series. Tonight's webinar is titled What Men Need to Know, the 10 Most Important Terms to Include in Your Settlement Agreement. I checked before. I'm going to check one more time to make sure that you can see the screen that's being presented. I'm changing the way that I transmit this evening, so I'm going to check in from time to time to make sure that everything is clear. So somebody could just take a second on the panel that you have on the right side of your screen and just indicate if you're able to see the PowerPoint presentation before we start moving along in it. Anybody? Just type a note into the questions. Okay, good. All right, so we're going to go into this now. Give you a little background of what to expect for today's webinar. It is scheduled for 60 minutes. It's sometimes shorter, it's sometimes longer. I never really know how long it'll take me to get through the material. My preference is to try to keep it as close to the time as possible. I do like to leave about 10 minutes afterwards for questions. However, I will take as much time as necessary to get through all the questions, regardless of how long the seminar is. It's just not everybody's able to stay online and longer than that hour, so I'll do my best to keep it that way. It's a one-way communication, so you should be able to see the screen and hear me, but I can't hear you. Also, I want to confirm that we're on the next slide that says today's webinar, because again, with the new way of presenting this, I want to make sure that everybody can see it. So if somebody could just take a second again and shoot me up another message. Okay, we're good. So it's one-way communication. I will, like I said, be taking questions at the end. I usually recommend that you post your questions at any time in the question section, because it'll remain there throughout the presentation and I can get to it at the end. That way you don't forget about it. We make sure that we don't miss anything and we cover all the questions before we conclude tonight. Let me give you a little background about me. If you haven't worked with me, this is me. I'm Brad Micklin. I'm the managing member of the Micklin Law Group. We are a boutique law firm concentrated in divorce, family law, and estate planning issues in Nutley, New Jersey. I am a member of the New Jersey and Pennsylvania state bars. I can appear and licensed to appear in both state and federal courts. I began my legal career as a law clerk for Judge Austin in the special civil part of Bergen County. That's a one-year position. So from there, I went to Kessler & Associates in Clifton. I did complex commercial litigation for a number of years. Realized that while I liked the complexity of the litigation, I didn't really care for representing businesses. So I left there and opened my own practice and concentrated into divorce, family law, and estate planning. Been in my own practice about 15 years, practicing for about 20. My firm, again, is concentrated in divorce, family law, and estate. I handle more of the complex and high net worth cases. These I put up in my webinars not to boast or brag, but for people that either are or will be working with me in the future, it's always good to know that you are working with somebody who's qualified. Unfortunately, a lot of people don't know if they have a good lawyer until afterwards. Here are some of the awards I've received recently. American Academy of Trial Attorneys, American Institute of Family Lawyers, Martindale-Hubbell, one of the largest lawyer databases in the country, and a number of others I don't put onto the display, but if you ever come to see me in the office, most of them are there if you have any questions about that. Moving along, let me give you a brief summary of what we're going to cover today. This is actually the second part of a two-part series. Last month, we did what do women need to know in the top 10 settlement issues to include for them. I was interested to see that in both of these webinars, I have a lot of the opposite gender that registers for either of them. And I think that's great because issues are often gender specific, but it's good to know all the issues and it's good to know what the other side is thinking so that you can work with them or at least counter them if it's more adversarial. And I'm also not going to necessarily tell you terms to put into the agreement, but more or less issues to consider, some ideas of terms to put in there, but not anything, word for word verbatim. So let me give you a breakdown of what we're going to cover. And you may notice there's actually 11, even though the webinar is the top 10. And that's because the first one, Pendente Lite support, is not an issue that goes into a settlement agreement. Pendente lite support is actually support that's set in the beginning of your case, as opposed to a settlement, which is at the end of the case. However, the topic and the issues I'm going to discuss with pendente lite support are so important that I felt it really needed to be addressed, even though it's not part of a settlement agreement. Second is reimbursement of expenses. This will relate to child-related expenses, unreimbursed medical and extracurricular, most commonly. There could also be tuition and other related educational costs. Custody, we're going to talk a little bit about the best interest standard and how it can apply and be utilized in your agreement, as well as dealing with potential either current or future alienation issues if you believe that that will be an issue in your case or can be an issue in your case. Along with number 4, which is parenting time. We'll also touch on some alienation topics, but it's really going to be just how to protect the time that you have. It is still unfortunately true men usually are not the custodial parent on average, so their parenting time is significantly reduced to what they're accustomed to and they're living as an intact family. So I'll give you some idea of how to ensure that the limited amount of time you get is preserved. Talk about cohabitation, what it is and how to define it for the purposes of protecting yourself in alimony, if there's going to be alimony in your case, current or future, and modification issues. Talk about relocation, which goes to custody issues, but it's a significantly different topic. If there is or will be a chance of relocating both in and out of state, we'll discuss a little bit about that, how to handle those issues before they arise. College contribution, how it's calculated. I'll tell you about some of the factors the court looks at and how to ensure that you are involved before and during the selection process, not just afterwards when they're asking you for a check. Next is modification, termination of alimony. It's going to be different than the cohabitation at number 5. Cohabitation is a very specific issue with the new modifications to the alimony law, so we handle modification and cohabitation separately. But I will talk about specifically on a more general basis how to terminate or modify alimony and how to protect yourself in an agreement that includes that. Counsel fees, I'll let you have some sense of what the court rules say and how to ensure that you get more than the court rules say. 10, which is emancipation, when that is supposed to occur and how to better define it so that you don't have to come back to court and fight it out at the time that emancipation may be occurring. And lastly, tax returns. For this webinar, because I did touch on this a lot in the first one also, I'm going to talk about how to protect yourself against future IRS audits and issues that arise post-judgment. So let's turn to the pendente lite support. Now, pendente lite support is support. It's a legal term that describes temporary financial support to a spouse during a divorce proceeding. It is ordered somewhere in the beginning, most of the time in the beginning of a case. The intention is to preserve the marital status quo. So more often than not, your pendente lite support, I'm sorry, there's a typo in the beginning. At the top, I changed it on a different PowerPoint, but not on this one. So it's pendente lite, not life. It's a Latin phrase, so spell check doesn't pick that up, so I apologize for that. It means while the matter is pending. And it is more often than not higher in the beginning than a final alimony award will be, because they're trying to preserve the status quo. So often you split one house with one income into 2 houses with the same 2 incomes, and they're trying to preserve as much so that the lower earning spouse is not financially coerced into settlement or out of the litigation. The IRS code at 26 U.S.C. IRC 71 defines 7 different things that alimony needs to have in order to be tax deductible, because alimony is tax deductible. However, pendente lite support is not always tax deductible, which is the issue I want to discuss. Is how to ensure that if you are paying pendente lite support, that you do get to take it as an alimony deduction. First, it has to be defined in the beginning. So if your lawyer is filing for pendente lite support, you need to ask that it be defined as a cash or check payment, that it be called tax deductible, that it be stated that it is not child support. It must end at the other spouse's death. You must live apart. You must not be filing joint taxes, and you cannot front load, meaning you can't pay more in the beginning and a lot less at the end. So in a pendente lite application, which most of the time men are responding to, you need to ask the court to include these provisions in the award so that you are able to later take it as a tax deduction. More often than not, the courts will call what's titled unallocated support, which means it's not alimony, it's not child support, and they want you to allocate it later, which means if you don't allocate it later, you don't get the deduction. More often than not, it's overlooked by people. The spouse that's receiving it doesn't want it to be declared alimony later because they have a tax burden that didn't contemplate or plan for. So if it's not provided for in the beginning, you're often going to lose it at the end. Even if you can't get the court to write in those 7 criteria I just named, you want to at least, and they're calling it unallocated, you want to at least have them put into the order, or on the record at least, that the intention is to later allocate the award so that the tax deductibility issue can be resolved. You want to at least preserve that to the extent possible. Now, the ironic thing about the current status of the law is most judges will say it's unallocated, and they're trying to do it to keep you from being able to allocate it. Yet the case law, I think it's Keene versus Commissioner, it says that when it's considered or called unallocated, it actually is all alimony and all deductible. The problem becomes if the judge says one thing and the case law says something else, you either have to take your risk and hope it works out for you, or you have to take an appeal, which is a very long and very costly process you want to avoid if at all possible. So, and the best way to do that is to indicate somehow, whether it's on the record, during argument, or in your court order, that the intention at a minimal is to allocate the unallocated award for tax deductibility purposes. Now let's move on to what would be the top 10 issues to put inside of a property settlement agreement. First is reimbursement of expenses. This, and it's more often in high conflict cases, reimbursement of expenses seems like it should be something very easy to do, and it often becomes very, very taxing and cumbersome. And you can also be on the opposite side of somebody who thinks they're trying to get it from you but isn't doing it the right way, and you get penalized because it appears as if you're just being obstinate. So the 2 main types of unreimbursed expenses are unreimbursed medical and extracurricular activities. So now, the unreimbursed medical, a couple things to realize. First is under these expenses will be resolved somehow through your child support payment and your child support guideline. The child support guidelines, which will determine what your child support is supposed to be based on income, is presumed under the law to be the correct number. So once the numbers are plugged in, you're given an amount, and that's how much you're supposed to pay. It is supposed to include the first $250 per year per child of uncovered medical expenses. The thing about this is that is a large sum of money for uncovered medical expenses per child per year. It should cover things like co-pays, prescriptions, could be vitamins, medicines, things like that. So in most cases, it doesn't really exceed that. Now, the extracurricular activities are presumed to or are included in child support guidelines. So you're actually not required to pay them unless you agree to pay them. And it's important to know going into a settlement agreement that extracurricular is included in child support. So if you're being requested to contribute to it or you're offering to contribute it, just know that you're doing more than you need to, and at least make sure that that's understood and somewhat appreciated. So when it comes to the provisions for paying these, because you don't want to get trapped into something, paying for something that you're not, or in a case where maybe their parents are paying the bills for them and then they're getting reimbursement from you, you want to put in a provision in your agreement that speaks about how and when payments will be required, how much time is supposed to be, what kind of proof are going to be required. Like, for instance, I always suggest my clients get not only a paid receipt, but a proof of the payment made, because just because a bill says it's paid, it could have been negotiated down and satisfied. They could have offered half and it had been marked paid. So you want to know what was actually paid out of pocket and by whom. You also may want to add a provision in that defines what these expenses are. Like I was saying with healthcare, it can be vitamins, it might not be vitamins. A lot of children nowadays have severe food allergies and significant costs associated with that. So The question becomes, is food considered a medical expense for these children? You might want to define what is and is not extracurricular activities, healthcare, medical expenses also. The purpose behind these recommendations is simply that you want it in writing what the other person needs to do to get money from you, so that you don't become an open checkbook and filing and fighting motions because they send you an email after they bought sunglasses and they said these are prescription and you have to pay for it. It might seem trivial, but these kind of things add up in mostly high conflict cases. Moving along to what is often considered a much more significant issue is custody. These, I'm going to give you some just proposed ideas for custody. Custody, again, predominantly goes to the mother at our current stage. While I am seeing a lot more fathers receiving custody, I'm seeing a significant increase in shared physical custody. Primarily, it is still women who are receiving custody. So the first thing you want to realize is that all custody decisions are made under what's called the best interest standard. They will determine what is in the child's best interest when making all custody determinations, which is important because even though you may have agreed to custody, it's always subject to change. It's always considered temporary in New Jersey. So anytime they're going to serve or anytime they're going to look at an interest, they're going to look at the best interest of the child. So with regard to this, and from a general standpoint, you will have two designations in the average custody situation, and that one is the parent of primary residence, called the PPR, and the parent of alternate residence, PAR. And the parent of alternate residence, usually dad, has like a visitation parenting schedule. The things you want to put into your settlement agreement are terms that speak to the fact that both parents are equally capable of being the custodial parent, albeit you're designating one as the PPR, the parent of primary residence. In no way suggests that that person is better or more qualified. And by putting the language in there, you're preserving your ability to revisit the issue later, that there was no specific reason why you could not have custody. Now, a couple other issues here, name change and alienation. These are, again, more just suggestions for you. I've seen issues now. We have a lot of new blended family issues. The divorce rate is higher than it used to be. Sometimes you want to put in a provision that the custodial parent won't have the child call anybody else dad. That's a very big issue, and it sometimes happens. It may be intentional, it may be unintentional, but putting something in there clearly defines that it can happen so that you have a right to address it immediately. Second is alienation. Again, this is a very big topic. It's also a popular buzzword. Alienation, as a side point, takes a very, very long time to accomplish. So if you believe you're in a situation where the custodial parent is trying to alienate you, long as you stay aggressive and on top of it, enjoying your parenting time and bringing problems of that into court, it's not likely to actually occur. But you may want to put in provisions that indicate that they won't engage in this conduct. And especially if they were engaging in it during the litigation, you may want to put in some terms that reference the applications or the arguments that were in court or the problems that were encountered. And should they continue, that there may be a change of custody. Now, you don't necessarily need to use the word alienation because that may be off-putting and difficult to get in a settlement agreement, but there's nothing wrong with indicating if X, Y, and Z happens in the future, like it happened during the litigation, that it may lead to a change of custody. One, it will most likely prevent it from happening, and two, if it does happen, it allows you to get into court and quickly fix it or change custody. All right, moving on. Parenting time. You want to, here is again just a recommendation. You want to include a provision in your settlement agreement to make up parenting time if you miss some. The problem with parenting time is it's hard to enforce because courts don't like to micromanage your parenting, and it's something that happened in the past. So there's very few remedies to make it up, and the most common is make up parenting time. But you don't want to be having to run into court every time something's missed, and courts are not going to be that fast to really assist you because they can't micromanage it. The procedure is you file a motion, that gets scheduled in 2 months. The other person responds, and a month later you have oral argument. At that point, it's usually moot. There's very little they can do. But if you put in a provision like this, it gives you a lot of control, because first you want to define what type of notice is needed if they're going to be canceling your parenting time. How much time should they give you? What method should it be? So you don't want them to say, oh, well, I called you at home and to tell you I was gone, but they knew you were on the road or on a train to come and make your parenting time. You want to make sure that they know exactly how and when to communicate with you. And you want to put around these terms, if it continues, it could be a change of circumstance that can allow for a modification of custody. Similar to what I was saying about the custody issues. These terms you want to include, especially again, if you have high conflict cases or these issues are prevalent in your settlement, they're certainly going to be prevalent afterwards, because the sort of belief I go by is people on their best behavior when they're in court. So if they're interfering with your custody and parenting rights now, it's certainly going to be worse when it's over. So your provisions always want to include the specifics of what kind of conduct is necessary, and always that a breach of it, intentional or accidental, can lead to a change of custody, because otherwise it's difficult to use them as such. But putting them in there shows that both parents agreed to it and thought it was in the best interest of their children to put these terms in. Now let's turn to some grown-up things. Let's talk about cohabitation. Cohabitation used to be defined loosely by case law as a marriage-like relationship. There was a recent amendment to the alimony statute which attempted to codify a lot of practice in the courts and in the world. They tried to take what was actually happening and make it law so that it'd be consistent, because the alimony law in New Jersey was quite archaic. So they changed the definition of cohabitation in good and bad ways. And the definition is a mutually supportive, intimate, personal relationship in which a couple has undertaken duties and privileges commonly associated with marriage or civil union, but not necessarily in the same household. The good thing about this is they said it's not necessarily in the same household. It eliminates one issue that you needed to prove by having usually a private investigator and a significant investment. But the worst part is all of the words they put in here, and this was just recent, this was like a year or two ago, all the words in here will have to be eventually be defined. What is mutually supportive? What is an intimate personal relationship? What is the privilege and duties associated with marriage? I mean, all of these can go in a million different directions. So now typically, according to the new law, alimony can be modified if there is cohabitation. Now, the thing about this, and most of the things I'm going to talk about, is again, their ideas. So the important theme to remember of all these suggestions, especially this one, is you are not bound by what the law says. And that's where a lot of people fall short, lawyers and clients. If the law says this is what we agreed to and we put in our settlement agreement, but you're settling your case, you can say and do anything you want. So the first thing you want to do is clearly define what cohabitation is. I give an example here. You want to define how long two people have to live together to be considered cohabitating. You might even want to include, I'm starting to include in my agreements now, it doesn't have to be an intimate personal relationship. It could be a family member. I mean, if you're paying alimony to your, I'm going to just say wife because this is a webinar for men. If you're paying alimony to your wife and she moves home with her parents, it's not any different. It's probably even worse than cohabitating with an intimate partner, because that intimate partner may eventually leave. Parents are probably not going anywhere, so that support will continue almost indefinitely. And there's no reason that you shouldn't be able to modify or terminate your alimony based on that type of cohabitation. But if you don't have it in your agreement, you can't, because the law says an intimate personal relationship, which I guess, as I think of it out loud, intimate personal relationship could be family. It hasn't been defined. So if you're on the other side of that issue and it's not in your agreement, then you would want to argue that the law should be expanded. Other things I think you should talk about, good faith notice. You should have the other person obligated to tell you when somebody is living with them, especially if you define how much time up here it's going to be considered to be cohabitating. And the reason you want to do that, one, is so that you know, but two, even if you don't know, if they're the kind of person that wouldn't tell you, then you can go back once you find out and argue that your modification of support should go back to the date it occurred, because they had a good faith obligation to tell you and they agreed to it and they didn't. Lastly, you can consider putting in a term for retroactive modification or application of the change. Again, if you find out later whether or not you have this good faith notice, if you find out later you want to get the money back that you paid during the time that you should have told you, even if there wasn't a provision for it, you can still argue that in good faith they should have told you because the issue was obvious. And I don't believe the new law allows for a retroactive modification. And what the new law does allow for, what people believe it allows for, is for it to terminate and then commence again if the cohabitation stops. So basically, you file a cohabitation, you prove it, their alimony stops, so they move the person out, then they get alimony back, and then they move the person back in again. You can go in circles. It's a really odd piece of law right now, but you might want to consider putting in a provision that says once it terminates, it's over. You can't revisit the issue after the cohabitation has ceased. Now back to some child-related issues, relocation. Relocation is often a big issue. Now, when you hear about it mostly from lawyers, you'll hear about it being out of state, out of country relocation. But relocation in New Jersey can be just as difficult on a relationship, if not more so, than some relocations. I mean, if you live in North Jersey, where I'm located, you can move 15 minutes and be in New York. You can go 2-3 hours and still be in South Jersey. So when it comes to relocation in state, when it comes to relocation out of state, that is this provision here. They must get either your permission or the court's order to move. And that's not really an issue I'm going to mention, except for globally. And that is that you should address it if you think there's an issue of relocation. You want to put what's going to happen in the event. But I want to talk more about the relocation when it's a changed circumstances and they're inside of the state. You might want to have a provision that includes a distance that they can or can't move, or that if they do move, it's considered a change of circumstances, substantial change of circumstances, which is the reason for changing support or custody. I gave 20 miles as an example. It could be 5 miles. I wouldn't necessarily recommend 5 because I don't think courts will look to that too rigorously. But you want to define how far it is and what changes would actually occur if this is going to happen. Are you going to have a change in your parenting time? Does child support or custody get changed? And this is important because there's going to be things like with parenting time, for instance, you're going to have to talk about how much time you're going to be driving, who's going to be doing the transportation, who absorbs the cost, the gas, the tolls. Give me 1 second. Also, with child support, now child support is based on an overnight schedule. Now, if you have a child all day, but you bring them home at night, you don't get the same kind of adjustment. Now, you may be losing time or losing days because the distance prevents you from exercising as much parenting time as you did in the past. You might want to include a provision that says how child support will be affected and modified so you don't have to go back to court and file a motion to do it. And again, with custody, as with anything, you might want to put in that a relocation at a certain distance or a certain amount of time, whether in or out of state, would be a reason to change custody. If it's in the agreement, the courts have to listen to it. Now again, just before we move on, going back to your custody issues, these will always turn on the best interests, but it's always important to have them included. Next is college contribution. A lot of issues to talk about college contribution. I may not spend a great deal of time because I think I'm a minute or two over where I should be. But college contribution has been a big issue in the news recently. Many of you may have seen that case where the girl sued her parents to have them pay for college. And the reason that case came up, and it settled, by the way, because nobody wanted the issue to actually be addressed. The case came up because there's an underlying constitutional issue or problem in the way that college contribution law is handled in New Jersey and probably throughout most states in this country. And that is, if you're married, you don't have to send your child to school, and the state can't make you send your child to school. But if you get divorced, they can. So there's a significant fundamental unfairness in that needs to be addressed at some point in time. Now, what I believe is going to happen is over the next decade or two, I think parents' responsibility for paying for college is going to be diminished. At least the state's ability to order parents to pay for college is going to be diminished. And that may be important when you're planning a settlement agreement for young children currently that may include college, because you may be agreeing to more than the law can require in the future. Now, as an aside, sometimes I put into my agreements that all of the terms or specific terms are interpreted under the law as it exists the date of the signing, so that you don't need to worry what's going to happen in the future. You at least know. But I guess it goes to how much of a risk taker you are or not, because that could, backfire both ways. But I always think it's safer to go with what you know, even if it's not favorable, than take a chance of what the future may bring when it comes to interpreting the law. So basically, let's talk about how college is done for a little bit. Newberg versus Arricchio is the lead case. Here's the citation if you want to read it. Probably go online and just type in Newberg, and it'll be one of the first things come up. One thing you want to include is a term that requires that you be involved. And you want to define exactly what that means. You want actual involvement. You want to know in advance of the applications. You want to know how many applications are being submitted. You want to be present for the visits to the schools. You want to be present for all the interviews. And you want to put in this provision, if you are not, then you are not required to contribute whatsoever, or the contribution can be voluntary on your part, but the court has no authority to order it. It's very important because, again, in a high conflict situation, you may get an email, oh, we picked this school and now you need to pay. And it's starting in September, and these courts are going to be hard pressed to tell a child, well, you can't go to school next month because of the way your parents handled it. But if it's 6 months, then there's some leeway for the other parent to figure out how to correct it. Another issue to talk about is the level of school. Not everybody even agrees that their child should go to school. I've seen a lot of agreements where people have said, no, I don't support my child going to college. Or if their child wants to go to college, he or she will have to pay for it, him or herself. You can put in, I'm not agreeing to college. Or you can put in a level of school. You can say that it has to be commensurate with their abilities or their life goals, or with our income standards. You don't want them to go to Harvard if you're a modest or lower income. Additionally, if you're going to have contribution provisions, you want to include a definition of, a definition of how much contribution. Often you can do it in a percentage. It can also be proportional to your income. I would also recommend along this line, if you are speaking of contribution amounts, you want to define what is and is not a college expense. Do you want to include computers, which are usually a necessity? If they're going to live away, are you going to be paying for furniture and bedding and sheets and things, And if so, you want to also provide that you're going to be included beforehand, so that these expenses that you are agreeing to pay, you'll contribute an involvement in deciding it, so you're not just, again, hit with a bill. One last thing to realize, there's something called the Rutgers rule. I don't know if it's actually deemed that in the case law, if that's what we just call it, but there's the case down here that actually talks about it. That's where people say, and you could consider this for your agreements, that regardless of the school that they choose to go to, I'm only going to pay for the amount of school I would be paying if they went to a local school like a Rutgers. And then the balance has to be figured out by them, but it won't be your responsibility. Moving on to more support-related issues, let's talk about modification or termination of alimony. Now, modification or termination, you always want to use both words, even though a modification can be a termination. But always put in both if you're making a settlement agreement. Now, let me quickly just give you some background. The types of alimony that you have, each one is modified for different reasons. So right now we have pendente, which we talked about. Reimbursement, which is to pay back one spouse for contributing to another's career or business. Rehabilitation, which is to help a lower earning spouse get back in the job market. Limited duration alimony, which gives a fixed period of time, usually for the similar reasons of rehab, is to help them start a new life and move on. We have open durational, which is the new word the statute calls for permanent, which can terminate at retirement, unemployment, cohabitation, or any substantial change of circumstances. And then there's term also, which is not really a statutory one, but if you agree to just a term of alimony, you're again outside of the statute, and which you can do. Rehab, or let me go, PPL, Penendente lite, doesn't get modified until the end, which then is pointless. Reimbursement, alimony cannot be modified pursuant to statute. Rehabilitation can be modified if the circumstances that were anticipated have not occurred. Limited duration cannot be terminated or can't be modified to extend the time period, but it can be modified to increase the amount. Open durational, I covered that, retirement, unemployment, cohabitation. And then term would be whatever you agree to. So, So when you're talking about provisions to put in, again, like I said, modification and termination, kind of the same thing, but you may want to just address them. You want to specify the grounds for termination or modification. You don't want to rely on the statute. There is a case where people, because the statute, for instance, says, like I said, retirement, unemployment, cohabitation. But if you don't say those things, or if you don't say it terminates based on what the statute says, and you just assume because it's the law it's going to apply, it won't. There was a case came down about a year or so ago that said because the parties didn't define when modifying alimony would apply, the court had to go back and have a trial on what the intention of the settlement agreement was before they could even look at the alimony agreement. So you want to specify, regardless of what the statute said, the reasons for modification and termination. You also might want to include a provision about how much time to trigger it. The statute right now says, for instance, 3-month unemployment for open durational, and I guess probably rehab also. 3 months unemployment is sufficient to wait before filing a motion for modification. Well, that can be devastating. If you're unemployed for 3 months and you have significant alimony obligations, 3 months, by the time 3 months comes that you can file, and now you have 2 months at least before you get into court, you could be so significantly behind in your arrears, you could lose your driver's license, you could be incarcerated. So you can modify and reduce or even eliminate the waiting period. You can put in a provision that says, if I lose my job, it's a change of circumstances. Now that doesn't usually go over too well because they don't, the other side's going to argue that, or you could do that intentionally. So I would usually put in a phrase that says, if the loss of employment is unintentional or not due to the actions or inactions of my client, then modification is appropriate. Same thing for termination. You might just want to define. Now, you also want to first put in that terminates at death, marriage, or cohabitation. Now, even though the statute does say this for most of the alimony types that you can agree to, you still want to say it because you want it to be clear. You don't want somebody arguing that because you didn't say it, it wasn't intended, which is exactly what I'd be saying if I had the other side in the case. But it can also terminate for any other reason. You can put in any other reason that would terminate. You lose your job, they get a job, they move and cohabitate. It can terminate. You don't have to rely on the statute. And this, again, I say throughout these webinars all the time, you don't have to rely on the statute because you're making your own agreement. Counsel fees. You want to put in a provision that says if you're forced to file an application because the other spouse violated your agreement, you're entitled to any and all legal fees. Now, the way the current law on fees in family stands is the starting point is everybody pays their own fees. The family law does allow, and there's a case Williams versus Williams that will go through a handful of standards for the court to determine whether or not to get fees paid to the other side. They look at the financial abilities of both parties. They look at the good and faith positions, and then they'll make an award. And additionally, the law says if you're filing a motion for contempt, enforcement of a provision, that legal fees should be ordered. But the problem is in all of these, whether the Williams case law or the contempt motion case law, Law speaks about reasonable legal fees. Reasonable legal fees are usually never close to what you actually incur in prosecuting these issues. And I think the reason why judges don't award all legal fees is they don't want anybody to be rewarded for coming into court. I think they want you to do whatever you can to stay out of court, good or bad or indifferent. So if you spend a couple $1,000s in legal fees to file a motion to compel, a weekend of visitation, parenting time, and you got all your fees back, the next time you have any parenting time issue, they think you're going to run back into court, which is not going to happen. But that's the mentality. So you want to put a provision in the agreement that says any and all, because reasonable gets defined by the judge. If your agreement says all, then you argue again, this was the agreement and it can't be modified. Courts, the public policy is not to modify the parties' agreement. So if the agreement says any and all fees, it should be any and all. But remember, this cuts both ways. So if you have it in and you're not in compliance with providing life insurance information or something as an aside, it will cut against you. But more often than not, you're listening to this webinar because you're in a high conflict or you have significant issues approaching that you anticipate being on the bad side of. This will be a very important provision to have. Emancipation, which is the end of child support, defined as when the child reaches a fundamental dependent relationship between the parent and the child is concluded. The way the case law defines it is they say when the child is moved beyond the sphere of needing parental influence. Now that is generally going to be at 18. It's actually a presumption at 18, but it's not required. It's not an unrebuttable presumption, meaning the court still can look at issues like these: the needs, child's interest, child's resources, family's expectation, ability, and any relevant factor. Issues of emancipation become significant in many contexts. First is going to be a child with special needs, any special needs, whether it be a food allergy, a form of autism, or just developmental disabilities. A court's going to bend over backwards to provide support for children. And technically, emancipation, while presumed at 18, isn't terminated in New Jersey until you go to court and terminate it, which is a point to remember. And we'll get to all that in a second. But a custodial parent, one, often cares so much for the child that they see them as a child, regardless of their age, and will underestimate their actual abilities and influence their or prevent them from moving beyond their own sphere of influence. So I think one of the things you need to look at is putting in a provision when emancipation is considered to have occurred. And I think you also want to have a provision about being notified when they are reaching that, or even if they believe that they are not reaching it, to be notified why they shouldn't. Just take a look at the next slide, give you more specifics here. This here is primarily what the law says are the reasons for a child to be emancipated, whether they're at 18 or after. Turning 18, graduating from high school, marriage, moving out of the house, death, armed forces, and full-time employment. Again, this is not the end-all be-all. You could have a child who's graduated high school, working full-time, living at home, and mom still says that this child has not moved beyond the sphere of parental influence. The child is not financially independent, whether it be because of special needs or because of just the lifestyle that they're leading. You can put in a provision that says that it is automatic, that you don't need to revisit the issue. Again, parties can agree to whatever they want. Another thing I think you want to include is a retroactive adjustment. Now, the law does technically say when you file for emancipation, it can be retroactively granted to the date the child should have been emancipated. Let's say you thought the child was in college for a year and you found out the child wasn't, or even the child went to college but you found they really made no effort whatsoever. They got all D's and F's and never attended class, but they were registered. You can seek a retroactive modification of the payments you made. The problem is, the reason why I suggest you put this in your agreement that it is retroactive is so that you don't have to worry about a judge who, while he or she may know what the law says, isn't going to follow it because they think it's not worth your money to take an appeal. So they sort of make the decision what they think is going to be the best for everybody or a little bad for everybody. But if you have an agreement with a retroactive clause and an affirmative obligation that you have to be notified, it's a lot more difficult for them to prevent it. Now, one quick aside on all of these issues that relate to children, you always will have the best interest standard that I talked about in the very beginning, because courts do have the freedom to a limited extent to change an agreement for the children's best interest, even if it conflicts with the parents. But the courts are required to first accept what the parents said was in the child's best interest, because you have a constitutional right to parent your child the way you want. But most people don't realize this when they go in before a judge who denies them something that they're entitled to. Moving on to, I believe, our last topic is tax returns. Tax returns are a big issue usually, and I discussed this a lot in my first webinar for women. Tax returns are usually discussed for support modifications. I want to discuss what happens to usually the higher earning spouse. More often than not is also is or was self-employed, and that is when there's a post-divorce audit or reassessment of taxes and liabilities. There are several reasons that the other spouse, while maybe even agreeing to contribute to certain liabilities, will claim that they shouldn't. Here I have the first most common is innocent spouse, where they claim that they didn't know that there was underreporting, for instance. There's other relief, like separation of liability, where they can separate who pays what, and equitable relief. But the innocent spouse is more often the problem that I've seen. When there's an assessment, you'll have a tax return audit. Now, the provision should say something along the lines of the ex-spouse not only enjoyed the income, but had knowledge. Because the theory, and this is what is underlying your negotiations when you're talking about it at settlement, is that if you didn't pay the taxes on the income, then the spouse and the family had more money and enjoyed that. Well, now if there's an assessment that's got to be paid back, they should share it too. But you want to put in a provision that they knew about it so that they can't then try to take the IRS, because the IRS is not bound by what the courts say. The IRS can do whatever they want. So your spouse could go and say, I didn't know anything about it, I had no knowledge, and they're going to decide whether or not to enforce against both of you or not. If you had this provision in your agreement, you can go to the family court, and the family court can enforce them to pay it, even if the IRS later determines that they didn't need to pay it. I had a case where the ex-wife agreed to pay $40,000 towards an $80,000 tax bill. It's in the agreement in that language. Then filed innocent spouse relief and said, I didn't know anything about the debt. And the IRS believed it and eliminated her responsibility to pay it, went after my client. We had to go to the court and get a court order and a judgment against her to levy against real estate to make her pay her share, because the IRS accepted that she said she didn't know anything about it, even though it was in the written settlement agreement. So you want to have these things spelled out so that there's no question about it when it later arises. So in closing, a couple things to remember. First is, like I said throughout all of this, you're not bound by what the law says. You're not bound by what your lawyer tells you or what the judges say. You can put in anything you want into your agreement. Agreement is just a negotiation. You give and you get. So keep these in mind, especially if you have high conflict, high asset cases. These issues, at least identifying these issues, will hopefully help you a significant amount. Additionally, but separately, I don't want people who may have already gone through a divorce to think that if you don't have these in, that your agreement's bad, or if your lawyer didn't suggest it, then you have a bad lawyer. Not all cases require these issues. Not all parties will agree to these issues. Again, I look from a standpoint of a high conflict case, but it's simply every case is going to be different. And why I tell all my clients divorce are not complicated, people are. So your ability to negotiate these terms are going to vary case by case. With that, I'm going to open up to questions. I see there was a question or two posed throughout. So there's a question posed, do I have to pay alimony to a working spouse? I'm sorry, this may take a sip. That's a very difficult question to answer. The alimony statute allows the court to look at about 14 different factors. In my practice, essentially, I think they look really at 4, and that is the length of your marriage, the lifestyle that you led, the higher earning spouse's ability to pay support, and the lower earning spouse's ability to earn money. So the longer your marriage, the more likely you'll pay alimony. And I usually look to between 1 and 2/3 of the length of your marriage can be the length of your alimony, which, by the way, the law says right now, if your marriage is less than 20 years, your alimony cannot be longer than your marriage. It's usually not as long as a marriage. That's why I usually go to 1 and 2/3 of the marriage. If you have the larger the difference of your income, whether it's her actual income or her ability to earn income, the larger the difference, the more likely you will be paying support. And what most people don't look closely to is the lifestyle. And people look at length of marriage and income discrepancy, and that's how they spit out alimony. And that's what I think motivated a lot of the law changes that came recently. But I think you really need to look at the lifestyle and the future needs of the lower earning spouse to determine how much is really going to be needed. I try not to make it just a money crunching, number crunching, but I really look at what's going to happen in the future. Because if you can make an alimony agreement that really works for both parties, then you'll have a better relationship. It doesn't have to be, well, I don't want to pay you anything, and the other one doesn't want to work. Find a middle ground. Find out where they're planning to live. What kind of car do they plan to drive? Are the kids going to go to school all day or use daycare? How much will daycare cost? These things can all be worked out so that you can set a number that really works or that really is what's necessary. Any other questions? I'll stay open and online for another couple minutes. All right, not seeing any questions. I'll give it another couple seconds. If for some reason you were signing on or out and missed the opportunity to listen to questions, or you think of something when I sign off, you should have my email. I think I would have sent you a confirmation. If not, let me just show you real quickly here. Is my contact information. Again, most of you probably have it in one way or another, but certainly can always contact me there, and if I can answer your question, I absolutely will. Otherwise, I want to thank you for coming out and listening to our webinar. I'll send you mentions of our next ones. We usually do them the last Thursday of every month. So I look forward to having you join us in the future. Have a good night.